rise. For the 5th District, State of Florida is now in session. Providing all presiding business closed court on your due attention, you shall be heard. May God save the United States of Florida in this honorable court. Please be seated.
Good morning and welcome to the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined this morning on the panel by Judge Torpy to your left, I think, and Judge Jacobus to your right. We have 4 cases this morning, all civil. We have panel changes for the 3rd and 4th changes, so I imagine that we will take the first 2 cases and then take a break. If you have a cell phone, we would appreciate it if you would turn it off so it doesn't disturb anyone. And with that, we will go ahead and call the first case, Ronald H. Roby versus TRICKEY. Mr. Roby, you'll have 20 minutes. If you'd like to reserve some of that time, please let me know and I'll set the clock.
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal at the end.
All right, sir.
If it please the court, my name is Ronald H. Roby. I'm here on behalf of Roby and Roby Attorneys at Law, PA, representing Ronald H. Roby, Attorney at Law, PA, a dissolved Florida professional association. We are here to...
Mr. Roby, how do you distinguish the Brigham case?
I'm sorry?
How do you distinguish the Brigham case? Brigham versus Brigham. It's a 3rd District 2006 case. How do you distinguish that?
From the instant case?
Yeah, right.
In the Brigham case, the issue was the complaint that was filed in the Brigham case was on the basis of a misconduct which resulted from misapplication of fees, etc. That's not the case here.
How can you tell that? Sir, how can you tell that from Brigham?
I'm sorry?
How can you tell that from Brigham? I mean, they sued for undue influence. There was a number of counts, and the Brigham court concluded that because the appellants defended against individual liability, that they had to get approval to get fees. Isn't that what happened in this case?
The underlying lawsuit in Brigham was based upon misuse of funds. That is not the case in this case.
Wasn't this case, sir, an allegation that the...
I'm sorry?
In the case before us, in your case, wasn't the allegation that the trust was invalid because of undue influence on the part of the son?
Correct. It was an attempt...
And so it was an allegation of personal misconduct against him.
Correct.
So how does he have the authority, and you as his attorney, how does he have the authority without court order to then expend what turns out to be the majority of the trust assets defending his own personal liability when Dad is trying to undo this thing, saying basically, and I don't know if it's true or not, but he's saying basically I was taken advantage of.
Well, to begin with, there is no personal liability on behalf of the trustee.
Well, but he was alleging personal misconduct. You exercised undue influence in getting me to set up this trust, this trust, and that was the allegation. That was really the thrust of it, wasn't it?
That was Esther's allegation, yes. Fred was incompetent. But what I'm saying to this court is that there was no personal liability on the trustee's part, because the thrust of the complaint was not to hold him personally liable. It was to invalidate the trust.
Well, there was also a surcharge, a removal and surcharge claim. They were basically trying to undo the whole thing, saying we got taken from day one.
Well, Your Honor, you're biting into the same red herring that Judge Powell bought into, and that is that the allegations of the complaint are sufficient to establish personal liability. That's not the case. And if the court will look at the entire docket, you will see that once the trust was invalidated, the whole matter went away. That was the purpose.
How much of the money went away?
And the purpose of the allegations...
How much of the money?
I'm sorry?
How much of the money went away?
How much of which money went away? There was over $300,000 initially.
And how
and
much
roughly $130,000, no, $104,000 was spent on attorney's fees in defense of the trust.
That was ruled to be invalid.
I'm sorry?
It was ruled to be invalid from the get-go.
No, Your Honor, it was not from the get-go. It was after the trustee was forced out, and he was forced out by these allegations which never were pursued beyond invalidating the trust. Esther wanted her husband's money back. That's the bottom line of this case. There was never any effort to hold the trustee personally liable for anything. The effort was to invalidate the trust.
So getting back to this Brigham case, I got it here. I don't see where there's any facts in that case at all as to what the factual predicate for the complaint was. What were the facts that the complaint was based on in Brigham?
The facts in Brigham?
Yeah.
The basic allegation was mismanagement of trust assets.
Where do you get that out of the case?
I'm sorry?
I see that they were sued for undue influence, breach of fiduciary duty.
The settlor died in 2002, and in June of 2003, appellees filed a multi-count complaint against appellants alleging, among other things, undue influence, breach of fiduciary duty, self-dealing, conversion of trust assets, mismanagement of trust assets. The basic personal liability aspect in that case was mismanagement of trust assets, which was the same.
You're just honing in on one count of the complaint. There was an undue influence complaint. Wasn't the holding of Brigham that when the appellants were caused to defend themselves against individual liability, that they had to get approval from the court before they could withdraw attorney's fees?
Yes, and what I'm saying to this court is that was the red herring that was thrown into this case initially by the Lowndes firm in order to deprive the trustee of the ability to defend the trust. The trustee had the duty at the outset to defend the validity of this trust. Whether he had personal liability or not didn't really matter, because his effort was to defend the trust, and he had the obligation to do that. If you will look at the decision by Judge Cohen in this case, what he said was, number one, the fees paid to recover the funds from SunTrust were justified because they were spent to benefit the trust. The fees that were spent to defend this trust by the trustee were to benefit this trust. They were to preserve this trust from the get-go, from the outset. To say that the funds that were expended in defense of this trust were not a benefit to the trust is like saying to a doctor who's just cured a patient, your services weren't worth anything. The effort that the trustee...
What was the benefit to the trust here?
I'm sorry?
What was the benefit that was conferred on the trust by your representation of the trust?
Preservation of the trust.
Well, the trust failed, didn't it?
I'm sorry?
Didn't the trust fail ultimately? The trust was set aside, right?
After the rug was pulled out from underneath the trustee by Judge Powell, yes.
Well,
Because the trustee did not have the ability to defend the trust any longer. He didn't have the personal assets, and neither did ESTATRICKEY have the personal assets to promote this litigation. That was provided by initially the Sawyer firm and then by the Lowndes firm. So you had the Sawyer firm and the Lowndes firm supporting litigation and then making allegations against the trustee that they didn't have to prove because they knew once the trustee no longer had trust assets in which to defend the trust, case was over. Never mind the merits, we have a technicality that we're going to use to destroy this trust. And that was Esther's point.
The trust, right?
I'm sorry?
The court set aside the trust right after you withdrew, right?
Correct.
You withdrew.
I withdrew, and the trustee threw up his hands and said, Esther, you can have it.
Well, how
Esther with his stepmother.
Sir, you can't interrupt me, okay, when I'm trying to ask you a question. We've got to have one person talking at a time, okay? So here's the question. After you represented this trust and then withdrew, and the trust failed, how can there be any benefit to the trust from your representation?
Because the trust existed through the time that I withdrew and the trustee threw up his hands and said, I give up.
Tell me what the benefit was that your representation...
The preservation of the trust.
The trust it wasn't preserved, sir. It failed.
It was preserved up until, as I said before, Judge Powell pulled the rug out from underneath the trustee and said, you can't use trust assets to defend this trust anymore. I think that was an incorrect decision. I think the decision by Judge Cohen to determine that these fees should be returned to the trust also was incorrect. And I've stated to you that there was the benefit to the trust was that the trust was preserved, and that was the duty of the trustee from the outset. And that's what he attempted to do with my assistance.
What does the allegation of champerty and maintenance have to do with the issue of whether the fees were properly paid without court order?
Well, why are we here? We're here because the Lowndes firm hasn't been paid. Why hasn't the Lowndes firm been paid? Because they had essentially a contingent fee arrangement with ESTATRICKEY, and ESTATRICKEY never paid them.
We're here, sir, because
I'm sorry?
We're here because you appealed the lower court's ruling.
Correct.
That said that you could not withdraw, or the trustee could not withdraw the funds with which to pay the fees without prior court approval.
Correct.
No matter what the Lowndes firm did, the only legal issue before the court is the one that you framed, isn't it?
Yes, it is.
How does champerty and maintenance of them have anything to do with whether or not the trustee properly withdrew these funds without court order?
Because if it were not for the financing of this litigation by the Sawyer firm and by the Lowndes firm, this case never would have gone forward.
There was
The
no
invalidation...
There was no suit brought below against...
I'm sorry?
There was no legal action filed against the lounge firm for champerty and maintenance, right?
No, there was not.
Was there
But we asked Judge Cohen to exercise his discretion in saying to the Sawyer firm and to the lounge firm, you never should have funded this litigation. And the court would then have the authority to determine that they were not entitled to any funds. The only reason we're here today is because they haven't been paid. And they haven't been paid because they had a contingent fee arrangement, and Ms. Hankins told Judge Smith, oh, I've got a soft heart, and that's why I represented this woman. Well, that's not a basis for funding litigation. That's taking the litigation on your own. Ms. Hankins said Mr. Roby should have avoided this by not representing Trickey to begin with, and once Judge Powell took away the authority to pay fees, he should have continued to represent Jim Trickey and proceeded. I'm sorry, that's not my obligation as a lawyer, and that is in opposition to what the Florida Bar says as far as our obligation to move litigation forward. We should not be promoting litigation, and that's what the Sawyer firm did, and that's what the Lowndes firm did.
What was the purpose of having an irrevocable trust in this case?
Because Fred Trickey knew that once his wife Esther got out of the hospital and found out what he had done, that she would be livid, and she was. She was so livid that she sought out the Sawyer firm, sought out the Lowndes firm, and set about to destroy this trust and get her money back that she considered her money when it was her husband's.
What was the purpose of...
My time is gone.
What was the purpose of having about $180,000 of the trust assets deposited into your trust account?
The Sun Trust activity. Esther Trickey, when she found out what her husband had done, went to Sun Trust and created such a turmoil that Sun Trust locked up the accounts. Jim Trickey came to me and said, you know she's going to do that to the rest of these accounts. I said, fine, get the money out and put it in my trust account. They won't be able to lock up my trust account. Those funds will be available to you to defend this trust. That was the reason.
All right, sir, you've got 3.5 minutes left.
Thank you.
Good morning, Linda Hankins, and I represent Fred and Esther Trickey. I think the Florida legislature had this case in mind when they adopted 737.403(2) in 2004. It's very clear if the trustee has a conflict with his individual interests and or exercise of a trust power, he must first get court consent to exercise that trust power. And the Brigham case is right on point. And it says it's clearly a conflict if the trustee has been sued in his individual capacity and wants to defend his individual conduct. In the Brigham case and in our case, conduct which occurred prior to the creation of the trust, because this is a classic undue influence case, you must first go get court approval.
How soon after the trust was created did the Sun file some pleading that was challenged the competency of the settlor?
I'm glad you raised that because you heard that Mr. Roby acknowledged that Fred Trickey was incompetent. It was just within months of them moving the money.
How many months, do you know?
I may have that. I think it was 3 months. It was an early part of the year. It may have been less than that.
And how old was the settler at the time that he created the trust?
92.
And how old was his wife?
91. And they
Did they find Mr. Trickey incompetent?
it was not adjudicated,
It was
but
not.
the panel found that he lacked capacity in several areas, but because there were other less restrictive means in place, a guardian was not appointed because ESTA was completely competent and able to care for him and had been the one managing the money, paying the bills. In fact, the Linda Trickey filed the guardianship proceeding against ESTATRICKEY,
Right.
and the court found that was filed in bad faith.
Right. Okay.
So they filed the 3 lawsuits. SunTrust had put a hold on the money at Fred and Nesta's request. We were trying to seek a constructive trust and order entered when they filed the suit against SunTrust. But they engaged in all kinds of conduct which did not benefit anybody. Didn't benefit their client, didn't benefit the trust, certainly didn't benefit my clients. When they filed those 3 suits, paid all the attorney's fees for all 3 suits, even though the guardianships.
Well, let me ask you, did Judge
Yeah.
Powell did he say, look, you can't take any more attorney fees out of the trust, or did he say, look, before you get fees, you got to file, the court's got to approve them?
He said both.
Okay.
He said, you can't pay any more fees without getting a court order, and you must do the accounting, sort of put some protections in place, and said, I'm going to defer the rest of the matters to Judge Cohen.
Okay.
The ROBY law firm filed a motion to try to get their fees paid. It was denied. They withdrew.
Okay.
1 week later.
All right.
When they took possession of the funds, it was 188 plus some interest payments, so it was a total of 194. In February 3rd, 2005, when I put them on notice of this statute, and I said, we object to you paying attorney's fees from the trust, they still had $170,000 in their account. 6 months later, when Judge Powell said, you need to deliver the remaining funds to a restricted account at Wachovia, there was about $30,000 left. The majority $130,000 had been spent on trust funds. Only $5,000 had gone to the Trickeys in that entire time, and that's because I got a court order. They refused to pay Fred's health care expenses. They commissioned the Cameron Group to do an evaluation of Fred, then refused to pay their expenses.
Was there other trust assets somewhere else at that time, or no?
The SunTrust assets. We were able to go there to get the health care fees, expenses paid, and other expenses paid. And when that money did come back in after the trust was invalidated, and we paid bills that were outstanding that had not been paid by the ROBY firm, there was less than $100,000 left. That is when, I'm sorry, what happened to these people upsets me. I did not pay myself at that time. I gave them that money because they had no other money. And they had health problems now, both of them, from the stress of this lawsuit, and Fred needed 24/7 care. We had tried to establish a budget during the lawsuit, which the ROBY firm objected to, that would have provided them monthly support and some money to pay their attorney's fees, because we did not have a contingency fee agreement. We had an hourly fee agreement. The Sawyer firm actually did get paid when we brought that money in from SunTrust, but our firm has not received fees. We have been paid all of our costs, and they did give us a $5,000 retainer that went towards cost. But what happened here was wrong, not only in the undue influence aspect of the case, but when the ROBY law firm got involved, told Jim Trickey to liquidate the funds, took a penalty, put it in their trust account, and they spent it as a war chest. Nothing that they did benefited their client or the trust. Yes, after they resigned, the case got resolved.
There has to be a benefit in order for there to be an entitlement to attorney's fees, is that right?
Correct.
So irrespective of whether you need court approval or not, at the end of the day, the judge still has to determine that there was a benefit conferred and what a reasonable fee is under the circumstances, right?
That's correct.
And the judge never made that determination because he just decided that the Brigham case rendered this and these were improper payments and required them to be paid back, right?
That is correct. He did find there was a conflict. I believe the law also at that time, through case law, said you can't retroactively approve it because the statute requires that you get approval in advance. You can't retroactively approve it.
I see.
And the law also says the attorney representing the alleged wrongdoer is in the best position to protect their interest to get paid. And the law is not too harsh. If failing to do that, they have to disgorge their fees and pay it back. They have refused to pay it back. They've also, you heard Mr. Roby say, he's representing a dissolved corporation. They dissolved their law firm structure and created a new structure to avoid this debt. And that is not something that's the subject of this appeal today, but it is in the record. And they did that without notifying the court, without notifying me, and they're saying that the firm that was representing them at that time is now
The
dissolved.
judgment is not against Mr. Roby individually, huh?
No, but there are supplementary proceedings that have been filed that would include that. So, the evidence that was available and presented to Judge Cohen at the time when he found conflict included testimony from the lawyer who prepared the trust, who said they were there under the premise that ESTATRICKEY had done something wrong. Now, if you remember, she was in the hospital for 5 weeks when Fred went to stay with Linda and Jim, and they took all the important papers with them because this was 2004, the hurricane season, and they saw that the accounts were joint, they saw their reciprocal wills, and they were concerned that the money, largely Fred's, that had been put in joint accounts in 1992 was going to go to all of the children and not just to Jim. So they identified the attorney. They went to an accountant and asked, what kind of vehicle do we need? They said a revocable trust. And the attorney testified they were there under the premise that Usta had put her daughter's name on Fred's one investment account and made Fred believe this. And this had been done without Fred's knowledge. They also led Fred to believe that if they didn't do something fast, they would withdraw all the money. And none of that was true. And Mr. Hinckley, the attorney, said if that was not true, Fred would never have been in my office, and I never would have drafted that trust for him.
There really wasn't any estate planning purpose for an irrevocable trust from a estate planning purpose like federal estate planning
No,
taxes.
that's correct. Fred had an 8th grade education. He was a truck driver. They lived in a double-wide trailer. They lived on Social Security and pension. They had their wills in place. They had living wills. They had health care surrogates. They had done everything they needed to do and were living within their means until Esther had the heart attack. Now, Jim Trickey even admitted, this is after the Roby firm was no longer involved, that his father didn't understand the trust. The attorney actually said, I don't know if Fred understood the trust. So he didn't realize he wasn't going to have control of his money. And how they found out, how Esther found out, is when she was released and was able to return home, no one had told her about the trust. No one had told her the accounts had been closed, reopened in new accounts with Jim initially and then into the trust. And she wrote their checks to pay their bills, and the checks were returned. And she called the banks. And of course they were panicked and they were frightened. And their checks bounced. The accounts had been closed. Their security in payments and pension payments were direct deposited into. They had no money. None. And none of that turned out to be true. There was one account that Esther had left because it was an account that also had her daughter's name on it. They left that account. It had $16,000 in it. That's how she initially paid money to the Sawyer firm and to my firm. And then our efforts were always to try to get these monies back and under their control. And the Roby Law Firm essentially barred every reasonable effort to meet the needs of these clients.
How much money was ultimately paid to the Roby firm?
$130,000.
And over what period of time?
It was a total of 8 months, but as I mentioned, they had only spent about $15,000 as of February 3rd, 2005. So they spent over $100,000 in the 6-month period from February to August 8th when they were cut off, and they withdrew. Now, we were ordered first to try to get the monies back from Jim Trickey. He didn't have any money. He's also a simple person. You heard Mr. Roby say Jim Trickey didn't have any money. So our first avenue was to try to get the money back from Jim. That was unsuccessful. And we've been trying to get it back from the Roby firm, and we still have been unsuccessful. But he was in the position to know what the client had and could afford, and that all of the allegations in the complaint were against him for conduct which occurred before the creation of the trust. Clearly, there was no issue that they should have gone forward to get court approval, and they would not have received it. The case would have been resolved, and we know that because it got resolved as soon as the ROBY law firm resigned. Thank you.
Thank you, ma'am.
Rebuttal. 2 items, Your Honor. The statement has been made that the trustee did not pay any of the expenses of Fred and ESTATRICKEY. He was prevented from doing anything because he was immediately taken up to Panama City so that his son couldn't talk to him. When he came back to Florida, there was only one occasion when he had an opportunity to talk with his father, and that was under the supervision of the lounge firm. They had hired Amy Cameron to supervise any contact. So he had no ability to determine what the needs of his father or his stepmother were. His father was the primary beneficiary of this trust. He made the effort to take care of these people. Immediately after Esther went home with Fred, he went over there with the checking account and left a checking account with her and explained to her what was going on. When she found out what her husband had done, as I said, she exploded. She was going to get those funds back one way or another. The other thing that I have to say to the court is, this trustee had no conflict. And the statute only requires him to seek court approval when there is a conflict. Where was the conflict? His interest as a beneficiary was to sustain this trust. His interest as the trustee was to sustain this trust. There was no conflict on that.
What were the total liquid assets of the trust? What was the total?
Of the trust, some over $300,000, $320,000, something like that.
Does it make sense for folks who have does it make any sense for folks who have such a modest estate to, in a period of 6 months, spend $115,000 to $130,000? In other words, a third to 40% of the trust assets defending the trust? I mean, it just doesn't make sense.
It didn't make sense to me either, but was there an alternative? I mean, Jim Trickey did not file this lawsuit. Esther filed this lawsuit with the financial support of the Sawyer firm and the Lowndes firm. It did not make any sense, which is one of the reasons that we initially said, do these people have any idea what they're doing? And that's why we filed the petitions to determine whether they were competent or not. And indeed, Fred was not competent. Thank you.
Thank you, sir.